every chance they can get to connect with the child and perpetuate the harm. And that's what we're trying to stop. All right, Mr. Archibong, isn't it true that Meta knows that the vast majority of CSAM shared on its platforms is shared via private messages?
I don't have that information.
Okay, could you take a look at Exhibit 44 in the larger of the two binders? It should be tabbed.
Okay, this is either the SIPO child safety overview or the email.
There should just
after
be
the 44 or before the 44?
It should just be the right after the 44 tab. So it's the SIPCO Child Safety IGWB overview. It looks like a slide deck.
Got it.
Okay. Is this a document generated by Meta?
My default answer is going to be yes on this one without perfectly understanding. I don't see a name on it. So, but there's Meta and Facebook icons and, confidentiality stuff that, not too dissimilar than the documents that we end up producing.
Okay, and it has a messenger icon in the bottom right corner as well, right?
Yeah, that's our standard, just icon potpourri.
Okay. All right, and you see the page numbering with the preface MTIGAG in the bottom right-hand corner, right?
I do.
I don't mean to interrupt, and you're about to ask another question. One of the things I would object on the basis of would be foundation. I was allowing him to ask the initial questions to see if he would lay a foundation for this witness to be able to speak to the issue. The agreement that we had between us on this document related to sealing and issues, but it did not encompass foundation, and the expectation is you have to lay a foundation to be able to address the witness with questions about the contents of the document.
So,
That's what I'm working on.
so at this juncture, are you objecting to further questions based on foundation? Because counsel said he's, by which you offer proof.
Well, I'm asking some foundational questions. I haven't moved to admit it yet, so I'm a little surprised to get the foundation objection in the middle of trying to lay the foundation.
All right, I will hold until
No worries, go ahead then, please.
Okay. Mr. Archibong, this slide deck, do you understand Exhibit 44 that we're looking at is a document that was created by Meta?
I go back again, I could assume, but I can't verify right now as I sit here.
Isn't it true that the state of Nevada and other states obtained what we're looking at here in Exhibit 44 in an investigation of Meta that predates this litigation?
I'm learning that now, but if that's the case, then okay.
Okay. Did you ever review Exhibit 44 to prepare for your testimony or otherwise?
I've not seen this in document end to end.
Okay. Will you take a moment and review the document more closely and let me know if you believe this is not a document that Meta generated?
Yeah, counsel, as I'm going through this, again, I have no reasons to not trust that this wasn't produced in some case that you guys were able to discover stuff. And this is not a meta document, you know what I mean? Yeah, this seems like work that we would do and thinking that we would do in order to think through some of the challenges or the opportunities that we have.
Okay, Your Honor, based on the witness's testimony and the meta base stamping and meta confidentiality and the council's meeting and conferring about sealing of this meta document, I'm moving to admit Exhibit 44.
We would object. There's no dispute that this is a document that's been produced in litigation, but what the issue is laying the foundation that this witness is able to speak to it. And so we would object to admitting this document on the basis of this witness testimony, given his lack of knowledge about it.
And of course, we have to sustain the objection. So far, the witness said he hasn't seen it, right? And to end, his last statement was, it seems like something he would have done. So do not have a sufficient foundation at this juncture, so I'm sustaining the objection without prejudice at this juncture. Because when you say agreement, there was not an agreement to admit it, correct?
No, not to admit.
Okay, that's what I wanted to clarify. I understood your agreement just was that it could be discussed without sealing that and giving it permission.
Well, my only response, Your Honor, is I believe his foundational objection relates to a question I might ask about the contents of the document. It's not that there's not foundation for the admission of the document itself. I didn't hear anything about the document.
Well, the court made a ruling based on the objection, based on what this witness said, with regards to the fact it not met foundational aspects in order for this document to be admitted at this juncture. So at this juncture, the court sustains the objection and denies the request to admit without prejudice. Just put it that for right now.
Sorry, Your Honor. Mr. Archibong, what does SIPCO stand for?
I do not know exactly as I said that.
Okay. Take a look at page 11 of Exhibit 44. Let me know when you're there.
I'm here.
Okay, do you see number 1 on page 11? It says CEI.
I do.
What does CEI stand for?
According to document child exploitation imagery.
Okay, and under heading 1, this document, Exhibit 44, page 11, says, quote, the vast majority of CEI, approximately 85%, is shared within private messages. You see that?
Objection, Your Honor. On the basis, this witness has no personal knowledge of this and is not able to give testimony regarding it based on his testimony thus far.
He can
So
say that
what's
he
your
saw it.
objection? What's your objection to the actual question that was raised? You just referred him to a page so far.
Well, he's reading the document and he's not established that there's a basis to get into evidence. He's just reading the contents of the document to put it into the record and asking the witness to say yes or no to what it is. If the document is not able to be admitted, then the contents being read in with a witness who said that he has no personal knowledge or foundation to speak to it is improper.
Counsel, would you like to respond? Because I'm only ruling on his last question was, did he see the particular page, right?
Well, he read the actual quote from the document as if the document is in and is able to use it, when the rule to not allow the document to come in is also relevant to the information in the document. If the document's not going to be able to be admitted, it wouldn't be appropriate for him to go page by page and read the contents of the document and ask the witness, do you see that, as a backdoor way of getting the contents of the document into evidence without having ever been able to establish that this witness has a foundation to speak to it or personal knowledge relevant to it.
Counsel, do you wish to provide a response?
Your Honor, I'm trying to lay the foundation and have him look at a few things. I don't know that just because the exhibit, I disagree, that just because the document itself can't be admitted, that it can't be used in the proceedings. It's used to impeach and refresh recollection. I asked this whole line of questioning related to this exhibit, started with the question, isn't it true that most CSAM is shared in private messages? And that's what I'm trying to establish. And so I'm having him review the document, and it may refresh his recollection that most CSAM is in fact shared in private messages. That's the purpose of using this document entirely, and I'm surprised that we're spending so much time on this part of it.
Counsel, I'll give you a brief response if you want, because the position has been articulated. It's not for the evidentiary mission that's being used for refreshing recollection. Court's aware of There's a specific process for refreshing recollection. It's been done a little bit different, but go ahead, counsel.
To be clear, I didn't object to his earlier question that just related to a general question about CCAM and knowledge. I objected to the question that related to him reading the document into the record. I do agree with Your Honor that that's not an appropriate process for refreshing a witness's
Not
recollection.
appropriate, I said a little different.
Well, I apologize. Well, I would maintain that it is not the appropriate course for being able to, the appropriate procedure for refreshing a witness's recollection in this situation where the witness has expressed a lack of knowledge about the document and no foundation to speak to the contents of the document, which is being read into the record.
The court's going to have to sustain the objection with regards to if its intended purpose was for purposes of refreshing recollection based on the witness's prior answer. Remember, you haven't asked if there's anything that would refresh his recollection, and then have him refer and read to something that potentially could refresh his recollection. His statement was he didn't know, and so he didn't say he didn't recall, he didn't remember, so there's really nothing to refresh, and so I can't find it for refreshing. I'm not seeing from impeachment, because you really haven't stated that he said something you're trying to impeach, and so therefore you have to sustain it on that basis because it's not proper impeachment. With regards to the third basis, that the fact that it sought to be, quote, specific evidence presented to this court, and the fact that the exhibit has not been admitted, the court can't take into evidence the contents, right, of the document. As at this juncture, it's a hearsay document, it hasn't been admitted, and so feel free to ask your next question, but I need to sustain the objection with regards to the last question. Go ahead.
Sure. Mr. Archibong, you're the head of the entire messenger product line, correct?
That's part of mandatory jurisdiction, yep.
Okay. And is it your testimony here today that you don't know, one way or the other, whether most CSAM is shared in private messages?
I do not have that definitive data at the tip of my tongue.
And I'm not asking for definitive data. You're saying you don't know whether most CSAM is shared in private messages?
I do not have that definitive data.
Well, what definitive data are you thinking that I'm asking for?
You're asking me to compare private messages, groups, to public feeds, to emails. I just don't know. I don't have that definitive data.
Isn't it true that the white paper in Exhibit L does not tell consumers that the vast majority of CSAM is contained in private messages on Meta's platforms?
Can you point out where in the white paper you're referring to?
No, I cannot point out a negative. I'm sorry. My question is, isn't it true that that information is not in the white paper, specifically that most CSAM is shared in private messages on Meta's platform?
Yeah, I wasn't the author of the white paper, nor was I there at the construction of the white paper. And the question that you're claiming here, I can't confirm it right now. I have no knowledge of it.
Have you ever reviewed the white paper?
I have.
How many times have you reviewed the white paper?
I don't know.
Did you review the white paper in preparation for your testimony in this case?
The declaration, yes.
Okay. Did you review the white paper?
Yes.
Okay, so you reviewed the white paper to prepare your declaration. All right. All right, and Your Honor, isn't it true that, well, actually, I'm going to have you take a look. Can you look at tab 63 in the larger binder? And before you start looking at the document, isn't it true that by July of 2021, Meta knew that parents are often unfamiliar with end-to-end encryption and don't realize its trade-offs?
I don't have any knowledge of that or the timing.
Okay, is your answer, you're saying you're not sure if Meta knew that information?
Saying by 2021 that we knew what?
That parents are often unfamiliar with end-to-end encryption and don't realize its trade-offs.
I don't have knowledge of whether we knew, said, or anything along those lines.
Okay, take a look at Exhibit 63. Let me know when you're there.
This is an email.
Yes, and I've actually been asked not to use the employee names in the message exchange here, so unless council's changed his position on that, I'd ask that you do the same thing, and we'll avoid stating the names. That's fine from the state's perspective.
We agree on the sealing point that was described just now, that the names in the document we'd ask to not be disclosed.
You can appreciate at this juncture, given there's a current media recording of this proceeding and it's being asked after, there's not a way realistically to exclude at this juncture, but I think you're just really saying prospectively asking the witness not to mention names, is that correct?
That's correct.
That's correct, and I will not be using names in my questions, and if the document gets admitted, we would agree to redact it before it takes its place in the court's record.
Appreciate it. We'll do it at the end, we'll take a little bit of that. Feel free to continue your question, counsel.
Okay, Mr. Archibong, isn't it true Exhibit 63 is an exchange of information between Meta employees dated in July of 2021?
That I do not know. Can I take a few minutes to read the document?
Sure, and I would just direct your attention to the dates. There's a date at the top and a dozen people with email addresses that end in @fb.com.
Just while the witness is reviewing the document, we just wanted to check in terms of time frame, in terms of what we're looking at. I know we've gone about a half an hour since great. We're not objecting, we're just raising an issue.
The counsel, you can appreciate most of that was you all's objection, the colloquy back and forth when he said he didn't know to something. So I'm not gonna reduce the time of one side when there was objections.
I understand, Your Honor.
I'm almost done, assuming we can move through this quickly.
Realistically, I'm gonna give it a few more minutes because I am not taking into account the time utilized by the objections. And the awareness didn't do it for your side. Okay, appreciate it, thank you. I am presuming both sides want the court to have the full information available to, so they can make one of its well-reasoned decisions, right?
Of course, Your Honor.
So I don't think giving you all more time is in any way adversely impacts either side, so go ahead.
Mr. Archibong, I'll withdraw the pending question and maybe come back to it. I'll start with this question. Is @fb.com an email domain controlled by Meta?
It is an employee domain.
Okay. And so with about a dozen people at the top of Exhibit 63 who have the @fb.com email address, would you agree that this is a message exchange between Meta employees?
Definitely looks like Meta employees. And then the message exchange thing is tripping me up a little bit because it's an email, but it seems like there's this back and forth between people, which email is not structured in this particular fashion, but maybe it's the matter of the exhibit or something.
Sure. All right, so would you agree this is a Meta document?
Meta employee emails and back and forth.
Exhibit 63. And right near the bottom, it's the last bit of information on the page. You see that one of Meta's employees wrote, parents are often unfamiliar with end-to-end encryption and don't realize its trade-offs.
You can object to this on the same basis as the last document. He has not established a foundation, and reading the document into the record with the witness not having expressed any knowledge of this document and any basis. I haven't objected because I was expecting there to be a foundation laid, but he's not established it, and he shouldn't be able to just read the document into the record without doing so.
Your Honor, I'm impeaching him. He said he didn't know if Meta had knowledge in July of 2021 that parents didn't understand the trade-off that end-to-end encryption provided. End-to-end encryption is, according to this witness, the best thing since sliced bread, and everybody wants it, and he's the head of messenger for the whole world and pushed for end-to-end encryption. That was his testimony on direct. And we've been talking about the white paper that discusses, and Mr. Archibong told this court in his declaration that the white paper was intended to explain the rollout and the safety issues with end-to-end encryption. And I'm asking him if he's aware that parents don't often realize the trade-offs from end-to-end encryption. He said he didn't know as the head of messenger for the whole world. And I'm asking him to look at this document to see that Meta did in fact have that information.
Counsel, I'm going to ask you a question for clarity. When his answer was, I don't know, are you impeaching him on whether he knows or doesn't know?
Yes.
You're saying, usually an I don't know vote doesn't really go to impeachment if it's not a document that he authored or, has familiarity with, right?
Well, the question was, isn't it true that Meta had that bit of information, that parents often don't understand the trade-offs of end-to-end encryption? Isn't that true, that Meta had the information? That was the narrow scope of my question. He said he didn't know if they had that information. Now, he's been, when we look at his declaration, Mr. Archibong has been the Vice President of Product Management since August of 2019. That predates this email exchange by 2 years. And he's been the head of Product Messenger for, it's a 1-year anniversary, happy anniversary. So he is someone in a position to know whether Meta has this information. He said he didn't know if Meta had this information, and I am impeaching him on that to show that Meta did in fact have this information. And I'm not moving to admit the document. I'm just impeaching him on his inability to say whether Meta had this information. It seems like something Meta would want to know when it prepared the white paper before it told the whole world how safe end-to-end encryption is.
Because I'm hearing what you're saying, but I really see what Richard's saying as opposed to credibility of whether he should or should not have known, right, in his role. Because he said he doesn't know. So unless you're impeaching his answer, right, because you impeach an answer, and his response was, I don't know. So unless you're saying that he's not going to forthright, that's a different issue. But what the company ultimately would have known, I think this was credibility in his role and what he should have known, but I'm not seeing how it's impeachment, right? Because it's not an inconsistent prior statement. It's not anything that he's adopted in the past that you're presenting. So I don't see how it's impeachment. So if you want to give me a little bit more information on how it would be impeachment, please do.
Sure, Your Honor. The question was the narrow issue of whether Meta knew and had that information in its possession in July of 2021. He said he didn't know if Meta had that information.
But he's not the 30B6 for this particular issue. He's not being presented as the person who would have the knowledge, yes or no. And so when I'm hearing him say he doesn't know personally, right, whether Meta does, then you're trying to say that there's documentation you're trying to use to impeach his I don't know. And that's where the court's really asking the question based on the objection that was presented and how this would be impeachment for an I don't know when he's not a 30B6 and he would have only the scope of knowledge that he would have, unless you're really trying to address it from a credibility standpoint.
He's the Vice President of Product Management. He's the head of Product Messenger. He's offered a multi-page declaration going through the safety, benefits, and other considerations for end-to-end encryption on the Messenger platform. And Your Honor may recall, I gave a foundation objection on his direct examination when he was asked about what do consumers expect. Consumer expectations. Well, this goes to consumer expectations, and I'm also trying to impeach his testimony about how consumers, what I view is his one-sided testimony about how consumers want privacy in their messaging. And the whole point of the state's motion and this evidence that we've been putting on is that the white paper effectively whitewashes the whole safety problem for minors, and that is the scope of the state's motion, and to show that Meta understands that parents of children don't understand end-to-end encryption and don't realize the risks, and those risks are not identified in Meta's public statements. Most importantly, it's white paper designed specifically to tell the world about what the supposed trade-offs are. And my question to Mr. Archibong relates to impeaching all of his testimony about how safe it is and how consumers want it. And there are Meta documents showing that people often don't understand. It's parents of minors. That is the issue we're here doing today. He's the head of the whole company for this platform that this litigation involves. And so I realize he's not the 30v6 witness, but he is the head of Messenger. And Meta decided to bring him here today and submitted a declaration from him. And so I'm asking him, as the head of this entire platform that has more than 1 billion users, whether the company knew this information before it rolled out default end-to-end encryption.
Are you articulating that there's anything that you're impeaching from his declaration, that there's an inconsistent statement in his declaration versus his testimony? Right? Because you're saying you're doing it as impeachment. There's a distinction, right, whether or not you agree or disagree with his testimony, or you may believe or not believe his testimony. I need to address this, right? Because you're saying it's impeachment, and I've got an objection. And so I need to have an understanding of what you are impeaching from this witness in his role just as called as an individual witness, not as a 30b6 for purposes of preliminary injunction. I fully understand. I mean, read your 100+ page complaint and all your cause of action. We've been running for several hours, and it's pretty, it's very clear what the position is. I'm trying to go to the objection on impeachment. But you're saying it's impeachment, it's not affirmatively asserted evidence in a document that has not been admitted.
Your Honor, I am impeaching him, paragraph 32 of his declaration.
So hold on.
This is Exhibit A in the binder.
I don't think you're asking him to go to Exhibit A. I think you're just asking the court to look at
Yeah,
Exhibit A,
the
correct?
court.
All right. I saw the witness was going into a binder. I just was making it clear that you're asking the court, not him. Making sure that was clear. 1 second, please. I appreciate your providing this court on paper. What paragraph, counsel, please?
32, let's start there.
Sure. 1 second. I'm going to listen. Please feel free to re-ask the question, have the witness answer. I'm going to listen to see who addresses the issues in the declaration that you referenced. Go ahead.
Okay. Mr. Archibong, isn't it true that Meta knew by July of 2021 that parents are often unfamiliar with end-to-end encryption and don't realize its trade-offs?
Sorry, counsel, you broke up for the last, you said, isn't it true that by 2021, Meta knew, and then you broke up for me?
Sure, I'll lean in, thank you. Isn't it true that by July of 2021, Meta knew that parents are often unfamiliar with end-to-end encryption and don't realize its trade-offs?
Counsel, I can't answer that question. Again, if you're asking me to refer to this email or message thread or document that I've never seen, that I don't know any of the names on there despite their FB accounts. I think I recognize one name. It's hard for me to really look at that and draw any conclusions without knowing the people, knowing the roles, knowing what the nature of the conversation that they were having, knowing how credible the conversation was that they were having. So,
Isn't it true that parents expect Meta to take steps to help keep their children safe who use Messenger?
we think about how to make sure that we can build products and experiences that parents can use and can help with their kids who are using them.
Okay. Court's indulgence.
Of course. Please.
Well, back to your prior testimony, Mr. Archibong, you said the white paper in Exhibit L was published by Meta in order to, quote, detailing its strategy for rolling out end-to-end encryption in Messenger and promoting user safety, right?
I don't remember exactly what I said, but the white paper, and in conjunction with a number of other different things that we did during that time period, were to help people understand how we were taking safety very, very seriously as we were moving to an end-to-end encrypted world. Yes.
And isn't it true in paragraph 13 of your declaration, you said, quote, people have grown increasingly concerned about the safety of their conversations?
Without even looking at the declaration, yeah, as I stated up front, society, especially as more and more of our lives have moved to a digital world, safety, privacy are top of mind. Did I lose you guys? Can you hear me?
Yes, thank you. And in paragraph 30 of your declaration, isn't it true you told this court that as Mr. Zuckerberg explained at the time, Meta would work to build a privacy-focused platform around several core principles, including not only the availability of private interactions and encryption, but also safety, right?
That's right.
And isn't it true that safety on end-to-end encryption involves understanding the risks involved in end-to-end encrypted messaging?
Yeah, ask that question one more time.
Sure. And isn't it true that to ensure safety for users of Messenger with end-to-end encryption, that involves understanding the risks associated with end-to-end encrypted messaging?
That's right. Yeah, as a product development, we're always trying to assess the risk of what we're building and making sure that we can mitigate that risk as we roll products out.
Are parents often unfamiliar with end-to-end encryption?
As I sit here, I have no data that would be able to answer that in any affirmative or non-affirmative way.
So as head of Messenger, all of the information that you provided to the court, both in your declaration and on direct examination about consumer expectations, you have no information to share with this court about parents often being unfamiliar with end-to-end encryption? Is that your testimony?
I have no research that suggests that parents are unfamiliar with encryption.
Have you ever looked into whether parents are familiar with end-to-end encryption?
Yeah, again, anecdotal user research. I know that they're not in Nevada and they're not a youth, but the Uber driver was a parent. He clearly was very familiar with end-to-end encryption. So you do research.
Do you have any information to share with this court about parents often not realizing the trade-offs for end-to-end encrypted messaging for their children?
I do not.
As head of Messenger and a great proponent of end-to-end encrypted messaging on Messenger, you have no information to tell the court about that.
Just going to object, asked and answered several times.
We're just gonna overrule it because it was phrased different ways.
You can answer it.
So can you ask the question again?
Sure, so as the head of all of Messenger, you're telling this court that you don't have any information one way or the other about whether parents don't realize the trade-offs of end-to-end encrypted messaging for their children.
Well, now if you ask the question one way or the other, again, there was multiple rounds of research and engagement with external experts, internal experts who have thought about this over the course of the last couple of years, that as we were rolling this out, we wanted to make sure that all people that we were building for, and then of course, specific audiences, especially when we're talking about youth parents, were a part of the experience and understood the different trade-offs that we were trying to make. So if you look at a lot of the product features and the safety features that we've launched over the course of the last 4 years or so, you will see a bundle of them are features that were designed to help with parent supervision of Messenger, of the experiences that we were trying to roll out and that we were trying to build. So, you know, if the question is, were parents involved in how we're rolling this out in a very safe way, the answer is unequivocally yes. The launches, the features, the messages we put out there over the course of the last couple of years would demonstrate that and suggest that. So.
Okay. Paragraph 34 of your declaration. You told this court under penalty of perjury quote, let me get to the right place. This is line 9, actually 8. Quote, Meta expects that users would likely experience frustration or disappointment with Meta, particularly after Meta has publicized its plans to offer default end-to-end encryption on Messenger for years. You see that?
I do see it.
Okay. And so, how are you saying that you did not have any information before offering that testimony to this court, that you had no information about parents' familiarity with or unfamiliarity with end-to-end encryption, or parents' realization of the risks and trade-offs of end-to-end encryption messaging? Is that your testimony?
Object is asked and answered.
Overruled reference to a different provision of his declaration.
Sorry, the video paused again for 1 second. Can you,
Sorry, the court overruled.
where are we?
The court overruled the objection. The witness may answer. And if he didn't hear it, then you can repeat it if you wish.
Repeat it, please.
Sure. So before offering the testimony to this court, under penalty of perjury, about Meta expecting users of Messenger to likely experience frustration or disappointment with Meta if end-to-end encryption was not available on Messenger, is it your testimony that you provided that statement to this court without knowing one way or the other whether parents are often unfamiliar with end-to-end encryption or whether they realize its trade-offs?
The rolling of this out, again, we acknowledged up front, you know, all the way back to 2019, that we're going to be some trade-offs in how we roll this out, right? In an encrypted world, there are fundamental things that are different about how we have to build the product experiences and how we have to keep the community safe. So I go back to, you know, over the course of the last couple of years, everything that we've done with multiple audiences in mind. It's hard for me to like specifically target and talk about what I knew or what we didn't know about parents. But at a high level, we engaged parents, we engaged youth, we engaged old people, adults, in order to make sure that we were getting this experience right and that we were building this experience right. I go back to a big bundle of features that we launched probably a year, maybe a year and a half ago, maybe a little bit less than that, that were primarily designed to target parents and their involvement with how their kids, their teens would be using our products. The ability to see who their kids were following or messaging if the kids wanted to allow that, who the kids were reporting if there was any bad behavior, parents having access to that, time spent on the platform. So as I sit here right now, of course we work with parents to design those features and talk about those features and talk about the trade-offs and make sure we got the balance right as we were rolling this thing out. And part of the reason why it's taken so long. So yeah, there would be disappointment. I stand by my statement here, unequivocally, right? There would be disappointment in both, parents, youth, everybody who is using our product right now if we did roll out an encryption.
Okay. Mr. Archibong, were you involved in the rollout of end-to-end encryption on Messenger?
Yes,
Were you involved in discussions with others at Meta about the risks and trade-offs related to minors using end-to-end encryption?
yes,
Okay. Is it your testimony to this court that the information in Exhibit 63 was not brought to your attention?
yeah, so the answer is I've never seen this document before. If it is a document or an email thread or a chat thread, it's not clear to me. It was 2021. I recognize one name on here. So no, this was never about, we're a company of 70, 80,000 people. Conversations and this work is being done in all types of corners. I personally won't see every single thing. And this is an example of where that might be the case.
Okay, my question was not about this document. I specifically limited it to the information in this group of 12 Meta employees who are specifically discussing the risks of end-to-end encryption for messaging of minors. Are you saying that the information in this document was never brought to your attention during the rollout of end-to-end encryption on Messenger?
Objection to the question is being vague. What in the document, what is he describing needs to be brought to his attention. It's unclear what this question goes to.
Okay, sure. Let's go through it.
Realistically, I mean, the court was overruling the objection because it's referencing the document and it's reviewed the document enough to know that he's not seen the document and that he's not aware of the information in the document. But since prior testimonies, the court overrules it as being vague, and vague really isn't an objection on a preliminary injunction hearing anyway as an independent ground, but just taking it as being an objection, it's overruled for the reasons stated.
Okay, and we're talking about, Mr. Archibong, have you ever met with Mr. Zuckerberg to discuss end-to-end encryption?
I can't answer that. My instinct is no, but I've met with Mark on a number of different things and encryption come up once or twice in those conversations perhaps, but my instinct is to say no.
Have you exchanged emails with Mr. Zuckerberg about end-to-end encryption?
No. Not that I can recall right now.
Okay. Take a look at the beginning of Exhibit 63. The very first message, dated July 28th, 2021, says, "Hey team."
We're going to object to the reading of the same document that he has expressed on several occasions. He does not have any personal knowledge on, and there's no foundation to speak to it. This document has not been admitted. We're going to object to him reading in sections of this document.
Okay, Mr. Oh, I should wait for a ruling. Sorry.
I'm going to sustain, you can get the information by having him review it and then asking questions about it rather than reading it into the record. I'm telling you which way to do it, but I do have to sustain the objection based on the current status of the information provided to the court. Please.
Mr. Archibong, does Meta have a youth team?
Yes is the answer.
Okay. And did the youth team have a meeting with Mr. Zuckerberg about encryption in the context of youth using encryption?
I do not know.
you ever interface with the youth team?
My team does, and I do occasionally.
Does information generated by the youth team ever make it to you?
Are we talking about this particular document that I've never seen?
No.
What are we talking about?
Information generated by the youth team, does it ever make it to you?
Yes.
Okay. Has any information generated by the youth team related to end-to-end encrypted messaging ever made it to you?
The answer is yes on that one. Just trying to think of specific examples. I don't have any specific example to share right now, but I have a team that works with the youth team, and I review their work occasionally, so I assume that yes.
Did it ever come to your attention that certain individuals at Meta viewed end-to-end encryption as an adult-only product?
It did not. Again, maybe for clarity here, I've been the head of Messenger for product for about a year. It seems like these documents that you're pulling from were a couple of years ago. Teams changed, the company's changed. We frankly have laid off 20,000 people between this document and the time that we're sitting here, so.
Okay, take a look at pages 2, 3, and 4 of Exhibit 63. Did any of the kid safety studies identified on this list come to your attention?
Where on 2 specifically are you looking?
About halfway down, and I don't want to use names because they might be Meta employees, but after 3 names is the year 2021 in brackets, and it says Messenger Kids Value Props Research. And then there's a link. And then there's another person's name in 2021. And then it says Parent Safety Concerns. You see that?
So we're talking about on page 3.
2. Middle of page 2. There's a message about a third of the way down
I
with,
see
from, okay. I'm just gonna say initials of a person. But the date on the message is July 28th, 2021, 20/30/50 PDT. Do you see that? Do you see where I am, sir?
Yeah, I'm still reading the list right now.
Okay, I didn't know you were doing that. So,
Sorry, sorry. Yep.
were you ever made aware of the first study on the list?
Personally, no.
What about the second, third, fourth, or fifth? The others on page 2.
The delta here is that this is primarily about a different product that does not have independent encryption right now. Let's see.
Right, but I'm only asking whether any of these research studies came to your attention during the rollout of end-to-end encryption. So the first 6 studies on page 2 of Exhibit 63, did any of those studies come to your attention before you decided to roll out default end-to-end encryption on Messenger?
Not the specific studies, no.
Okay. How about the 6 studies identified on page 3 of Exhibit 63? Did any of those come to your attention?
Where are you starting the studies on this one? Yeah, I'm not quite sure the relevance of these studies or why they would come to me during an encryption rollout, because it's focused on an entirely different product, but, so.
Right.
That was the answer, but I'm not quite sure it's super relevant.
Okay. Well, the other product is Messenger Kids, right?
That's what this document seems to be referencing and talking about.
And do you have any involvement with Messenger Kids?
Messenger Kids is underneath my purview, yes.
Okay. And end-to-end encryption, Meta does not make end-to-end encryption available on Messenger Kids, correct?
That's right.
And isn't it true that Meta does not make end-to-end encryption available on Messenger Kids due to safety concerns?
I do not have any information that would suggest that's the case, or one of the primary reasons or drivers.
But you agree that end-to-end encryption, Meta has decided to not make it available on its Messenger Kids platform, correct?
We have, we're not rolling out on Messenger Kids right now.
Since you talked about consumer expectations before, do parents expect Meta, the manufacturer of the Messenger app, to play the most important role in helping to keep their children safe from unsolicited, dangerous messages?
So was there I heard something else coming out of the courtroom. So should I say something, or?
Oh, the court said bless you. Somebody
Bless you
sneezed.
to a person who was sneezing.
I thought I heard motion or something. Okay, sorry. Can you re-ask the question?
Sure. Isn't it true that parents expect Meta, as the app manufacturer for Messenger, to play the most important role in keeping their children safe from unsolicited, dangerous messages?
We invest pretty incredibly and heavily in ensuring that adults and minor conversations are good and healthy conversations. If you look at, again, some of the features that we rolled out over the last couple of years, it has primarily been to ensure that, adults that do not know minors or do not know teens can't reach them, can't discover them in our public forums, on Messenger. If they do, and somehow the child follows them, there is a bunch of product friction that we put into place to ensure the child actually wants to engage. So we do think it's pretty paramount to ensure that we, along with parents, can keep children safe, especially with our systems. Yeah.
Your Honor, I move to strike that. It's entirely non-responsive to my simple yes or no question about what parents expect.
First, to sustain the objection, I'm also going to remind you, counsel, I am taking into account that there was objection time period. I am taking into account you're getting longer answers. I'm also taking into account it has been over an hour, and I guess we're up to about an hour and 20 minutes. An hour and 20 minutes when realistically, right, based on the parameters, significantly shorter than that. So in order for you each to have an opportunity to do your close up, I'm just reminding you, right?
I'll limit it to 2 questions, assuming I get answers. How about that? And then I'll end.
The court's not limiting you to 1 or 2 answers. We are just going to need to ensure that everyone has the full and accurate available time frame that the parties agreed between each other. Go ahead.
I understand, and I greatly appreciate the court's patience. I'll re-ask that question since my objection was sustained.
It was.
Mr. Archibong, isn't it true that parents expect Meta, as the app manufacturer for Messenger, to play the most important role in keeping their children safe from unsolicited, dangerous messages? Yes or no, please?
I think the reason why it feels like not a simple yes or no for me is the most important role. As a parent myself, I consider my role the most important role, but I do expect the platform, and I think that we from Meta perspective want to show up in a very important way for kids. So it's a complicated, my bias is to say yes here, but the most important role that you throw in there trips me up a little bit.
Okay. And isn't that why Messenger Kids does not offer end-to-end encryption?
That is not priorities, assessing why when we roll things out. I'm sure there's a bunch of different factors right now that unfortunately I couldn't say definitively.
As head of product for Messenger, do you believe Nevada consumers have the right to know all of the safety-related information about minors' usage of end-to-end encrypted messaging that is in Meta's possession?
Counsel, you broke up again there at the very end. Can you guys hear me?
Sure.
Yep, sorry. Can you re-ask the question?
Sure. As the head of product for Messenger and a great proponent of end-to-end messaging, do you believe Nevada consumers have the right to know all of the safety-related information about minors' usage of end-to-end encrypted messaging that is in Meta's possession?
I don't know that I necessarily understand that question. When you say minors' usage and no, what are you referring to, or what do you mean exactly?
Do you believe, as the head of Messenger, that parents in Nevada have the right to know safety-related issues surrounding end-to-end encrypted messaging for their children? Everything that is in Meta's possession.
As the head of product, again, I believe that we've engaged pretty quickly and thoroughly with parents to understand how we were walking into this end-to-end encrypted world. So, yes.
Yes, you do believe they have a right to know all of the risks and safety information in Meta's possession?
I think that we've been transparent about some of the challenges and the opportunities that we had to continue to provide a safe experience for their youth.
Okay, no further questions, Your Honor.
Okay. Before we go to redirect, you can appreciate my wonderful team, and maybe you all also have been, we haven't had an afternoon break. Everybody needs an afternoon break, folks, so I don't think there's going to be an objection to taking a 10-minute afternoon break. Come back at 4:05. Here's the anticipation. Come back, I'm going to ask counsel for Meta how long you need for your redirect, because realistically, I thought you all might want some summation time, but you all have way exceeded the anticipated time that you all wanted for examination, and what would have been some type of argument time. So let's all take a break. We'll discuss that when we come back. No, we're taking a break right now, and my team needs a break under state and federal law. Please, we're going off the record. Thank you.
I was just.
No worries. Back on the record in case 886110. Counsel, I was going to ask you about redirect. Do you want to set what's forth? Would you want to set forth? Go ahead, please.
We have no further questions for Mr. Archibong.
Okay, then is he excused for purposes of the preliminary injunction?
On behalf of yes.
And on behalf of the state?
Yes, Your Honor.
Okay. So then that means, Meta, are you calling any more witnesses? Does that conclude the witnesses?
No, we are not calling any more witnesses, Your Honor. Thank you.
Okay. So then at this juncture, counsels, here comes the question, because you can appreciate you're way past the times you each estimated, the extra time you were given, and past even that. So what the court needs to know, yes, the witness is excused for all purposes. I'm sorry, I thought you heard that. Have a good one. Thank you.
Yes, best wishes.
All the best. Good luck. Best wishes. Okay. Thank you so very much. So then we're going to circle back to, does either party wish a summation? Or you wish the court to rule based on what I've heard thus far, as well as all the pleadings and papers that are all over?
Thank you, Your Honor.
And paper. Go ahead, please.
Michael Gayan on behalf of the state would like a brief summation, and I would also appreciate about 3 minutes to make the offer of proof that Mr. Jones brought up yesterday. Thank you.
We're going to get that. I was going to ask about that one next, but okay. So,
I'm narrowing it as we speak.
and how long, in your viewpoint, is a brief summation?
I believe if needed, I could do it in 7 to 10 minutes, in that range.
Counsel for Defense, do you also wish a summation?
Yes, Your Honor, we do wish a summation. We would prefer a longer time period than that.
And what is your view of a, quote, longer time period?
I would ask if the court's willing to give us the time, and I
Please don't
understand.
put the court willing to give the time.
Okay.
I just asked you what you want, counsel. Please
25
don't.
minutes, Your Honor.
How are you going to do that with the time, with heading to end of business day?
Your Honor, I had anticipated that, that there would be,
I know, but we are aware, our counsel, that's why I'm interrupting you, is because you can appreciate how long some of those objections were, you can appreciate a lot of the colloquy going on, we are where we're at. There's not 15 minutes left in the day.
I had understood yesterday, is the court able to go until 10:05?
Not unless you're asking my team yet again to do overtime.
Your Honor, that's why I said I'll be guided by how much time is
You might want
available.
a
but
ruling by the court, right? If you don't, just want your summation, and I say goodbye to you for the day?
I had assumed the court would take it under advisement, but I wasn't sure. That's what I had assumed, but.
You haven't practiced in front of this. But whatever, okay, let's,
But
but
Your
folks,
Honor,
you each get 20 minutes, okay? Let's balance it. Obviously, the state, you're not going to object to having 2 more minutes, are you? Because I also have to do their offer of proof. Which you want to do first, your offer of proof, or you want to do your summation?
I think I
Offer
should
of proof
do the offer of proof
Sure. Go ahead.
first. Thank you, Your Honor. Appreciate the time. I'll try to be brief, and just for the record, this relates to Dr. Jennifer Goldbeck and the information she would have provided to the court if she were permitted to testify. Dr. Goldbeck would have testified that it is technically feasible and could be accomplished with minimal burden. The relief the state is seeking, specifically turning off end-to-end encryption for minors in the state of Nevada. She also would have testified that Meta has actually changed its code, or has not actually changed its code yet, and defaulted all Messenger accounts to end-to-end encryption. And of course, indulgence.
Sure.
Before I get any further, I do want to note some of her credentials. She is
Are
a,
you saying these were presented to the court in any documentation that the court would have had available to consider as of yesterday? Because if you're going to present them today, right, the offer of proof would have been as of yesterday what the court had available to it. So you say that these were presented in a pleading?
it would have been presented had Dr. Goldbeck testified. It's Exhibit 40 in our binder. It's just her CV. I was going to discuss her credentials before getting into the testimony, just so I can show what evidence would have been presented had she taken the stand.
So you're not saying it's attached to any pleadings, you're saying it was a proposed exhibit in your binder?
There was a proposed exhibit disclosed to Meta, and it's in the binder, and it would have been used with Dr. Goldbeck if she were permitted to testify.
Go ahead, please.
Okay. Dr. Jennifer Goldbeck, she works at the College of Information Studies, the iSchool at the University of Maryland. She has a PhD degree. She has worked in her current position at the University of Maryland since 2018. She has taught many courses on both, she's focused her research and teaching efforts on aspects of social media and the web. She's taught university level classes on the web and social media. And she has also published and presented many articles referencing journals and conferences, with more than 150 of them relating to social media and the web. She has authored more than 150 scientific papers related to the web, as well as 2 books on social media and multiple other books on the subject matters touching on this case and specifically this motion. So going back to what the substance of what she would have testified to had she been permitted, that it would not be a substantial amount of effort or resources for Meta to change its end-to-end encryption setting for minors in the state of Nevada, that the burden would be minimal in the scope of Meta and its business. She also would have testified that even if the code had changed with respect to messenger and default end-to-end encryption, that rolling back to the code that was in place in December of 2023 before this change would be a comparatively easy thing for Meta to do, and that would only take a handful of engineers several days to maybe 1 to 2 months to accomplish. And also, finally, that Meta has a substantial amount of age information related to its messenger users, both from the account creation process, which requires a birth date, and it's mandatory for the users to provide, and also in users' profiles where they are encouraged to voluntarily add their age information and birth date information. Meta also has various sources for geolocation for its users, including GPS, IP addresses of the devices they are using, and other device signals. And because Meta has substantial amount of age and location related information for its users, it is feasible for Meta to comply with the court's requested injunction to make.
Court's requested injunction, counsel, I think you may have.
Excuse me, the state's requested injunction, sorry, I was distracted there for a second. The state's requested injunction to make end-to-end encryption unavailable for minors located in the state of Nevada. Your Honor, in addition, Dr. Golbeck has twice been designated as an expert in litigation against Meta, and she has gained just general familiarity, not specifically with the issues in this case, but she is familiar with Meta, and one of those litigations involved the messenger product, albeit about a decade ago, but she is generally familiar with this product and platform. So those are some of her other credentials, and that is my offer of proof, and I'm happy to move on to the summations.
Okay. Is anyone from Meta wanting to respond to that offer of proof? Or are we moving forward?
Simply to preserve the point, Your Honor, that we understand this is simply a proffer of what she would testify to. We think there would be a substantial basis for undermining those statements. But so we just wanted to be clear, we don't take that as anything more than a proffer of what she would testify to.
That's the context in which the court understood it, and the court's said the same understanding as yesterday, that based on all the reasons the court stated yesterday, there's not anything new that's been presented to this court. So this juncture sounds to me like you're going to summations. So my question is going to be, are you all going to do multiple people who want to do different parts of summation, or is one person taking it for each side? The court doesn't have a preference, I'm just asking.
Your Honor, Michael Gayan, on behalf of the state, it will just be me.
Your Honor, Timothy Hester from Meta would just be.
Then feel free for the full extent of everything that's contained in the motions, oppositions, and reply. Counsel for the state, do you need a moment or two, or are you ready to proceed?
If I could just have a moment, I would appreciate that, and then I don't need more than probably 1 to 2 minutes, if that's
No,
all right.
it's okay.
Thank you, Your Honor.
That way, counsel, everyone gets the same. Move off the record for a moment or two. Okay, now on the record, go ahead, counsel, stand about your summation.
Thank you, Your Honor. Greatly appreciate the court's time, the court staff's time. I understand that it's been longer than anticipated, but I really appreciate the court's patience on this important issue for the state. So one thing I want to make sure is abundantly clear, because a lot of the evidence from Meta seemed to muddle it up, is that the state in this action is only challenging messenger related to minors in the state of Nevada. And by this motion, it's even narrower. The state is only challenging the use of end-to-end encryption for minors, kids, the most vulnerable people in the state, or certainly in the group of some of the most vulnerable. These are children. Some are teenagers, but some are much younger. These are parents of children in Nevada. That's who we're trying to protect. That's what this motion is about. And you heard testimony and information about risks to children. You heard that from Detective Gonzalez. And you heard the impact on his work, Investigator Gonzalez, in his work attempting to keep children in Nevada safe, and that end-to-end encryption is an impediment. You heard evidence from Mr. DeFonseca on his efforts and how end-to-end encryption means he has much more work than he would otherwise have, and that it takes him away from his other duties. You heard testimony from Meta's own witnesses that go to some of these issues. And Your Honor, before I get into the evidence that you did hear, I want to also remind the court of the state's burden. I believe a lot of the evidence that has come in relates to things that are entirely irrelevant. And it's the NOS case cited in our papers. This is a statutory enforcement action brought by the state of Nevada. And the NOS case makes it clear that to obtain injunctive relief, the state, and I believe this is a direct quote, need only show a reasonable likelihood that any statute has been violated. That's it. This is not a traditional Rule 65 preliminary injunction brought by two other parties where you have all these equitable considerations and balancing of harms and benefits and who tips the scale the right way, and the court uses its judgment to decide whether injunctive relief is appropriate. This is a statutory enforcement action brought by the state of Nevada against Meta Platforms for the dangerous messenger platform and its use of end-to-end encryption for minors in this state. And the state has a right to bring this type of an action, and it has a right to enforce its laws and its statutes as it sees fit. And it doesn't matter the size of the defendant, they need to comply with Nevada's statutes. That's what this case is about. And and that is the burden. So just to be clear, that's the state's burden. So all of the testimony, including the offer of proof that I just made from Dr. Goldbeck, related to this purported difficulty that Meta would face from the relief that the state seeks, is entirely irrelevant. You go back to the NOS case, the Supreme Court, in a published binding decision, says the state need only show a reasonable likelihood that the statute was violated. That means all of the other considerations are gone. But we put on this evidence in an abundance of caution. Obviously, the court will decide how to handle that. But we believe the law is clear on the state's burden. Now, Your Honor, I want to briefly touch on personal jurisdiction, since that has come up a number of times. Yesterday, quite a bit, and then today, with some objections about what evidence should come in. I want to go make a few comments. First, excuse me, the court mentioned the Tricarici case yesterday, and we had some discussion about that. But I do want to point out the Tricarici case and the effects test in the Tricarici case is limited to tort actions. That was a tort action, and the case specifically says the legal effects test applies to tort actions. There are some torts in our complaint in this case, but there are also statutory violations, and that's what we're here on this injunction for. We're not seeking an injunction under our strict product liability claims. It is the Nevada Deceptive Trade Practices Act violations that Meta has engaged in. That's the scope of this hearing, and I know personal jurisdiction goes to the whole case, and so maybe the court has to consider the legal effects test for the tort claims that the state has asserted. But for purposes of personal jurisdiction, the court looks at the entire action, and I don't believe the court should be looking at or applying the legal effects test to our statutory claims or muddling everything together. I think the court has to take a global view on whether the state of Nevada has jurisdiction, or this court has jurisdiction over Meta. And
I have to stop you for one quick second. So are you saying the court has to split two different personal jurisdiction tests, one for the 598 claim, which is your cause of action 1 and 2, and another personal jurisdiction test for the rest of your causes of action? Just, if you wouldn't mind clarifying, go ahead, please.
Sure. Well, I believe Tricarici says specifically that the effects test applies to tort claims. It does not say that it applies to all claims. So under the Pool case cited in our papers, that's the correct standard for Nevada deceptive trade practices claim and what is required to show and have jurisdiction over the defendant. But I want to get back also to Tricarici. Some other things that are important from that decision. First, Tricarici says when you're at the motion pleading stage, which is where we are right now, that the state only needs to make a prima facie showing of personal jurisdiction. And Tricarici cites the Trump case for that proposition. Now, while the court doesn't need to accept all the allegations in the complaint as true, Tricarici does say the court must accept properly supported proffers of evidence as true and resolve all factual disputes in the plaintiff's favor. So, Your Honor, when you do that, when you resolve all factual disputes about personal jurisdiction of Meta in the state of Nevada's favor, there is no doubt left that this court has personal jurisdiction over Meta. Meta has registered to do business in this state, okay? It has made numerous public statements about the safety of the messenger product, including the white paper that we spent a lot of time on today. And those statements were intended, you just heard testimony, those statements were intended to affect people in Nevada as well. And with that, I want to turn to show the nexus between Meta's acts impacting Nevada and the claims in this case. Our Deceptive Trade Practices Act claims almost exclusively relate to misrepresentations and omissions. Specifically, paragraph 467 of our complaint alleges that Meta willfully violated the statute by representing that Messenger has characteristics, uses, or benefits that it does not have. Paragraph 468 alleges that Meta caused confusion or misunderstanding as to the safety and risks associated with the Messenger social media platform. Paragraph 470, Meta represented that Messenger was of a particular standard, quality, or grade. Specifically, that it was designed to be safe for young users, despite knowing that this was not true. Paragraph 471, Meta represented that Messenger was safe and not harmful to young users' well-being when those representations were untrue, false, or misleading. And paragraph 472, Meta used exaggeration and or ambiguity as to material facts and omitted material facts which had a tendency to deceive and or did in fact deceive. So, Your Honor, when you look at all of that information and apply the standard that this court is required to apply in considering personal jurisdiction, there is no doubt left that the court has jurisdiction over Meta and can provide the relief that the state seeks. Now, we dealt with this yesterday. Even if the court is still unsure about personal jurisdiction, the state would like the opportunity in that instance to do expedited personal jurisdiction discovery, including on some of the issues that these witnesses from Meta that testified today said they did not know. So we reserve our rights there and hope that the court would still permit such expedited jurisdictional discovery. Now, on to the actual evidence, Your Honor. You heard from Detective Gonzalez, or excuse me, Investigator Gonzalez, that the state needs, and he and his team and people like him who do important law enforcement work in the state of Nevada, they need the contents of the messages when they're investigating potential crimes against children, okay? He also testified that children here that he deals with are unlikely to report abuse to anyone. Their parents, law enforcement, anyone. They're unlikely to do it. So Meta's attempt to rely on victim reporting fails under that evidence, and that's unrebutted evidence. Inspector Gonzalez also said getting the message content from service providers like Messenger is critical for warrants and prosecution and stopping these bad actors from abusing children in Nevada. He also testified that families don't always cooperate. They want to move on. They're ashamed. They're embarrassed. They do not want to cooperate with law enforcement and provide devices for search. He testified that suspects will rarely cooperate at all. That's not surprising because they're under investigation. And he testified that predators preying on children in Nevada prefer Messenger because it allows end-to-end encryption and also because it is connected to two of the world's largest social media networks where these predators can search for and find children to abuse. That is the difference between Messenger and every other end-to-end encrypted messaging service that you heard from the Meta witnesses. iMessage, Signal, whatever. It doesn't matter. You heard testimony from Inspector Gonzalez that none of those are connected to a social media platform at all, much less some of the world's largest social media platforms, maybe the world's largest too, Instagram and Facebook. All right. The court also heard from Mr. DeFonseca that if a phone is locked, he cannot extract forensic messages at all. And he also confirmed that kids are preyed upon in Nevada on Messenger. Your Honor also heard evidence from Ms. Davis that Meta is not law enforcement. They're not involved in deciding what evidence is needed to secure an arrest and a prosecution and a conviction. Those people are people like Inspector Gonzalez. All right? Ms. Davis also testified that Meta doesn't prosecute criminal cases for child harm. They know that there is a serious concern that end-to-end encryption will degrade or interfere with law enforcement and safety capabilities. This is right in Exhibit 64. These are the talking points for Mr. Zuckerberg when he met with NICMEC, all right? And Ms. Davis was involved in preparing that document. And so if Meta anticipated that NICMEC would have those concerns, it should also anticipate that parents will have those concerns. Parents in Nevada, children in Nevada, teenagers who are maybe deciding which messaging platform they should use. This is information that consumers have a right to know, and this goes back to our deceptive trade practices claims that I outlined. This is information that Meta knew was a concern for NICMEC, and did not share directly with consumers. And if the court takes a close look at the white paper, you will not find this specific information, the information that was admitted in Exhibit 64 that Meta acknowledged as an anticipated concern of NICMEC. It did not disclose those concerns and that information in the white paper or anywhere else. You didn't hear any evidence from Meta that it disclosed that information somewhere else, some other public offering that was directed to Nevada consumers. You also heard from Exhibit 64, Ms. Davis. Let me just tick through the statements. That there's a specific risk to minors who are at risk of being identified in the town square, the public forum, and then taken into a living room, the private forum, like Messenger, by individuals wishing to harm them. They also said, we will never find all of the potential harm we do today on Messenger when our security systems can see the messages themselves. Now, Meta's witnesses tried to walk that back and say, well, we have all these preventative safety protocols. That does not change the unrebutted testimony in the missions, in the declarations that have been filed by Meta's witnesses that Meta cannot see message contents, and this statement holds true. Meta will never find all of the potential harm it did before end-to-end encryption on Messenger because it cannot scan the message contents and it does not know what people are doing and cannot stop it. Meta also knew that a concern was that end-to-end encryption is like locking kids in an unsafe place, even if you build protections, and locking NICMEC out. That was a concern. That's not been disclosed to the public, including people in Nevada. All right? Users want privacy, but not at the expense of child safety from child exploitation. What proof do you have that users want end-to-end encryption? Your Honor, you heard no proof from Meta today that anyone in Nevada ever asked for end-to-end encryption. There's complete void in the record of that, yet Meta repeatedly said consumers want it, but there's no proof of that being the case in Nevada. So then why not turn it off? If nobody in Nevada has ever asked for it, let's turn it off just for minors. And finally, you understand from Exhibit 64, you understand that you will degrade or interfere with law enforcement and safety capabilities. That was specifically tied to Inspector Gonzalez and his work, and end-to-end encryption degrades and interferes with Nevada law enforcement. You have ample evidence of that in the record before you. And Your Honor, Mr. Archibong, I'm not sure there's much there worth even talking about. I find it shocking that the head of Messenger and someone who appeared to have so much information about end-to-end encryption and the rollout on Messenger, the product that he heads for the whole planet, he had almost no information about child safety and child safety concerns on the Messenger platform related to end-to-end encryption, and he even admitted that end-to-end encryption is not available on Messenger Kids. Well, he wouldn't say why, but I think it's pretty clear why it's not available on Messenger Kids, because kids should not have end-to-end encrypted messaging. The court can look directly at Meta's own words in Exhibit 64 and what it knew NICMEC would be concerned with. That is why, and Inspector Gonzalez and law enforcement, that is why, because there are sadly many, many sick adults who are trying to take advantage of children and abuse children. And you heard from Ms. Davis that they are persistent and adversarial, and they look for every opening, every chance they can get to connect with the child and perpetuate the harm. And that's what we're trying to stop. And I thank Your Honor for your time and would ask that the court grant the injunction as requested.
And of course, got 3 questions, counsel.
Oh, sorry.